Oyez, 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 the Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. This is the second day of our March term here in Nashville for the Court of Criminal Appeals, and we're happy to be here. On the panel today, to my right is our court's presiding judge, Camille McMullen from Shelby County, and to my left, I'm privileged to have with me today Judge Tim Easter from Williamson County, almost in Davidson County.
Almost. Thank you.
He lives very close to the line, I think. And I'm Kerwood Witt. I'm from Monroe County in East Tennessee. Arguments today are 20 minutes aside. If you represent the appellant and you desire to reserve a portion of the 20 minutes for rebuttal, please make an announcement to that effect at the beginning of your argument. That said, we'll have our first case, please.
State of Tennessee versus Michael David Mosley.
Good morning, Your Honors. I'm Ben Russ of the Nashville Bar. I represent Mr. Mosley. I'd like to reserve 3 minutes of rebuttal time, please. 3 minutes.
I'm sorry?
Could I please reserve 3 minutes of rebuttal time?
Okay.
Thank you. I've tried to conceive of the most simple and clear way to talk about the main arguments that I want to discuss today, and perhaps some of the facts might be enlightening on that. I'm not sure if the court's had a chance to review everything, at least as far as the record goes. Perhaps the briefs have been read. In this, Mr. Mosley's case, he was at a bar here in Nashville one evening, and he was attempting to make romantic advances to a young lady named Emma Yoder. She did not want his romantic advances, and it became a little contentious. Several of her friends essentially told him to leave her alone. Not clear exactly what else was said, but I don't think he appreciated it very much. The bar closed and everyone was exiting, and as the bar closed, and there is numerous surveillance videos of this that the court I'm sure will review, Mr. Mosley started a fight with the group of individuals that were with Miss Yoder. It turned in basically to a brawl that lasted about a minute to 2 minutes, kind of spilled over onto the other side of the street. At one point, Mr. Mosley found himself on the ground and was being beaten. He got up approximately 5 or 10 seconds and kind of was pushed to the side about 10 or 15 feet. And then he came back and re-engaged in this, and he produced a knife. And 2 of the people that had been in this fight were killed, and another one lost his eye. Mr. Bethard and Mr. Trapani were killed, and Mr. Bethram lost his eye, which was the basis for the murder counts as well as the attempted murder count. The reason I go into that whole preamble is the state's theory of this case was that he was hitting on Miss Yoder. She didn't like it. Her friends didn't like it, and this led to the confrontation that led to their deaths. To take a step back, Mr. Mosley argued that he was using self-defense when the fatal incident took place. Prior to the trial, the state wanted a pretrial ruling, which it got from the trial court, about whether he was engaged in unlawful activity at the time that the killings or the self-defense occurred. And overlapping with that, they wanted a ruling on 404B or other acts evidence. There was a young lady who had accompanied Mr. Mosley to the bar, and she testified both in the pretrial hearing as well as at trial that Mr. Mosley and another associate had come to the bar in order to sell drugs. There is some further evidence that might corroborate that. It's a little unclear what Mr. Mosley's role might have been, but you do see him talking to various groups of people. At one time you see him leave, and the exterior cameras show that what might have been or could have been a drug transaction. That was the testimony of his other associate. So the state wanted to say that he's engaged in this unlawful activity, and therefore he is, one, not entitled to a complete self-defense jury instruction because of that, and two, they wanted to bring in that particular conduct as other act evidence. And the trial court ruled, this is where it gets murky, kind of combined these two things in its ruling. In the record in volume 1, page 117, the trial court ruled eventually, after hearing this evidence, that a material issue exists to show that Mr. Mosley was engaged in an unlawful activity other than conformance conduct in order to provide contextual background for the state to prove the necessary elements that Mr. Mosley did not act in self-defense. And so, by that ruling, the trial court A determined that Mr. Mosley was not entitled to the complete, and I refer to it as complete and incomplete, that the no duty to retreat language from 40.06, the self-defense instruction, was removed pursuant to the commentary and the procedure that's been established over the last few years with Perrier and the sentencing comment, the jury instruction commentary. So that was correct in so much as that was what the trial court should have done. However, one, we believe that that was an erroneous conclusion, and two, we think the trial court has improperly conflated these two things. The trial court, pursuant to this procedure that I'm talking about, should have determined whether Mr. Mosley was engaged in unlawful activity or not. And the case law, as well as the commentary, said that because this other unlawful activity might often implicate a 404B issue, the trial court should conduct a out of jury hearing similar to a 404B hearing. However, the trial court is the one that has to make the determination of whether Mr. Mosley is engaged in unlawful activity and whether that then informs its decision about the jury instruction. It's not the jury's decision as to whether he's engaged in an unlawful activity that affects what the jury instruction is going to be. But by this ruling and various other comments that the trial court has made, it does conflate these two issues. It says that because we believe there was this other unlawful activity and we think that that is a material issue, the other unlawful activity, then we think the jury should hear about this alleged drug dealing. There's a number of pitfalls with that. But the primary one, in my opinion, is, as the court's probably well aware, after Perrier in 2017 and numerous other cases that have come through this court that have clarified beyond Perrier, the unlawful activity has to have some nexus to the use of self-defense in order for it to be somehow germane. I guess the classic example would be that if someone breaks into another person's house and then is confronted by the homeowner, they are entitled to use self-defense, but they do have the duty to retreat. They're clearly engaged in unlawful activity, and the unlawful activity led to the confrontation with the homeowner or the person that might have had self-defense used against them. One of the cases that I'm not recalling right off the top of my head uses the example of if I had cheated on my taxes, I'm engaged in unlawful activity within the meaning of the statute. But it's hard to conceive of a way that cheating on my taxes might have led to some self-defense confrontation. So, though I am engaged in unlawful activity, there's no nexus between that and the use of force. Those are obviously very extreme examples. There are cases, however, and I cite both of them that I found, Jackson and Mustafa, that specifically talk about drug deals and specifically talk about how the drug deals were unlawful activity that did lead to the confrontation. But the reason I bring that up is because they're very distinguishable from Mr. Mosley's facts. Both of those tend to be a drug deal gone wrong between the party and the person who force was used against.
So how did the drug dealing come into play factually?
I don't think it came in at all, Your Honor. That's my entire point.
Well, so the testimony at trial was that the defendant
Yes.
came to the bar with the intent to sell drugs. Is that?
That's correct.
And was there ever any drug transactions testified to?
No. No drug Are you asking about the party that ended up in the fight? No. And that's my point. The state's...
What was the 404B? What was the issue with the 404? What was the
Based on the ruling that I read, when the trial court says that it's necessary to provide a contextual background,
Just the comment that the intent was to sell drugs, is that what was trying to be kept out?
Yes, that Mr. Mosley was there engaged in, I guess, multiple either attempts or successful drug sales. Yes, that was what Mr. Mosley wanted kept out. That was what the state wanted to bring in. And the purported reason was that either it was, again, the trial court seems to have merged two rulings here, but excuse me, strictly on a 404B basis. If it's contextual background, one, there's no analysis of the Gilliland factors as to why this somehow, the absence of this alleged drug dealing creates some void or misconception in the jury's mind. But even if there had been analysis, I fail to see how that's possible. Again, the state's theory is that this was unwanted advances that led to this altercation. The record is silent, which was the second point that I was making, Judge McMillan, that there is no indication that Mr. Mosley was trying to sell drugs to these folks, whether they wanted them or didn't want them. If that was the case, and again, I think you'd have to go a step or two further to show why that would actually have led to a confrontation if he felt he got cheated or whatever it may be. But the record is silent as to that. In fact, the state's theory is alternate to that. So as far as on a strict 404B basis, I don't see any connection between the other act's evidence. I do think, again, it's always hard to quantify, but my opinion would be that this is prejudicial and damaging information for the jury to hear.
What was the reasoning for the trial court denying this issue in your motion for new trial?
I would have to go back and look at the trial court's ruling there. I don't recall off the top of my head what the court's reasoning was. But this, of course, was argued, obviously, pre-trial by the trial attorney. Again, I don't see the connection. I think, again, the trial court's thought process, which I'm interpreting from its order, is that the jury needed to hear about this evidence because the jury had to make the determination whether this was unlawful activity, which is erroneous. The trial court had made that ruling, which I think is erroneous, but it wasn't the jury's decision to make. And therefore, and perhaps it's because it was more or less a joint hearing on this issue that wires got crossed, but I do think that it certainly has no 404B basis independently. Additionally, as far as the self-defense instruction goes, there is no analysis in what I've read. Of course, the court will have a chance to review the trial court's order, but there is no analysis as to how there's any nexus between these two things. Again, I think the trial court conflates contextual background with the necessity to hear about this evidence so the jury can hear or determine that there's unlawful activity going on.
I understand that the 404B issue was not argued in the hearing on the motion for new trial, but was it raised in the motion for new trial?
Yes, to my recollection, yes, it was.
Sir?
Yes, I believe so, Your Honor. I don't have a clear recollection of the hearing itself, but yes, it was raised. So anyway, again, I feel like the trial court judge has not only mixed these two issues up, but done it incorrectly on either issue. And I think that, again, this is not a harmless error. First of all, Mr. Mosley's entitled to a correct jury instruction. Second of all, his primary defense was self-defense, so any diminution of that defense can hardly be considered harmless, in my opinion.
He received the self-defense instruction, or the jury did.
Yes.
There was just no duty to retreat language.
Correct. That was left out. Yes, Your Honor. And again, just to say why it's prejudicial, I mean, Mr. Mosley is a small man. He's probably about 5'6", weighs about 130 or 40 pounds. There was evidence that numerous parties that he was engaged with were high school football players, very large men. And so if his argument is I'm using self-defense, that certainly would make sense. And again, the factual scenario that I talked about, and again, I go on for quite a while about premeditation, but I don't really want to argue that this morning with a limited time. As he's sort of pushed aside and disengaged there for the 5 or 10 seconds that he is, one, that's where the state determines that he forms premeditation. And secondly, more to the issue that I was talking about, if the jury doesn't hear that he had no duty to retreat, then logically they would think, well, why there is he not disengaging? So again, there's both his defense as well as the issues of premeditation, whether they've been proven beyond a reasonable doubt. So those are the reasons that I think the overlapping or intertwined issues of the incorrect jury instruction as well as 404B are meritorious for us. Lastly, I did want to address one issue that sort of overlaps, and that's improper closing argument by the state's attorney. I've cited it more thoroughly in my brief, but the state's attorney argued to the jury that if someone is free from excitement and passion, or rather the reverse, if someone's in a state where they are still excited or passionate, then that person has to be the equivalent of someone incapable of exercising reflection and judgment, incapable of thinking, incapable of making a decision. And then later on, she repeats something of a similar nature. That's clearly misstating the law. That would be more in the nature of a voluntary manslaughter. As the court, of course, knows, the only requirement for a second-degree murder is that it's a knowing killing of another. It doesn't require that someone be in some state where they're incapable of making a decision of any kind. But when she was allowed to argue that to the jury, leaves the jury with the impression that it's more or less an all or nothing. He was either premeditated, or if he wasn't premeditated, he had to be in this state of passion where he was incapable of making a decision according to their.
Well, both of these knife attacks were extreme in terms of penetrating the victims' bodies.
Yes.
As I recall. Does that not in and of itself can we not infer from that there is an intent to kill those victims?
Yes. Well, again, he killed them. The argument was not that it was somebody else or that it was an accident. He killed them. Mr. Mosley's argument, A, was self-defense, but secondarily what I'm saying here is the state's attorney was allowed to misstate the law. If he acted in premeditation, then the jury's verdict is supported. But the way that it's set up in the closing argument is that in order for him not to be acting with premeditation, that he had to be incapable of making a decision. And that goes to the heart of the intent elements.
Was there an objection?
There was not. But I would believe, based on what that the Atkinson factors are met here, I mean, the record is clear as to what was said by the state's attorney. There's no
Was this raised in the motion for new trial?
Yes, it was in the motion for trial, I believe.
And the reasoning of the trial court for rejecting it?
I would have to refer back to the trial court's order, but my recollection was the reasoning was fairly sparse on all issues that were raised by Mr. Mosley. But no, there was not a contemporaneous objection. I believe after the fact, either at the trial or maybe it was at the motion for new trial, but Mr. Mosley's attorney said essentially that he didn't want to draw attention to this, so he didn't make a contemporaneous objection. I don't know that that's satisfactory for plenary review. However, along the lines of what I was saying, I believe that it is plain error. I do think that, one, the court can make a review of what's happened. Two, that it was certainly an erroneous statement of the law, and that if it had been raised, I think that it would have been sustained. Third, there's no tactical reason that conceivably that Mr. Mosley would want this information in. I mean, it misstates the law and essentially takes away one of his lesser included offenses. I do think that it was clearly adverse to him. And lastly, I think that if there is no check on what the state argues in the closing argument, then I think it's necessary for substantial justice to address that particular issue. So I do think that all of the Atkinson factors are met there. I'm into my rebuttal time, so unless you have any more questions, I'll just save it for. Thank you, sir.
Good morning, Your Honors. May it please the court, Brooke Huppenthal on behalf of the state. I would also like to just briefly review a recitation of the facts. The proof showed that on the night of the offense, Michael Mosley went to the Dogwood Bar to sell drugs. And he did this by mingling with the bar's patrons. in the same moment, at the same time, he began to hit on Miss Emma Yoder, and she became increasingly uncomfortable with his advances. So her friend, Mr. Sam Folks, went up to Mosley and pretended to be.
You led your factual recitation with the defendant went to the bar to sell drugs.
Yes, that's correct.
How is that relevant to the fight that happened? And were drug sales involved with the instant, I guess, homicide here?
So
or the offenses, I'm sorry.
No worries. Yes, of course, Your Honor. I understand. So if the defendant did not go to the bar, if he was not trying to sell drugs, he would not have been at the bar. Miss Harper had testified that he was not selling drugs at the Copacabana, the bar that he had went to earlier in the night. And while it's the state's position that there doesn't need to be a causal nexus when it comes to the self-defense instruction.
Well, we have case law authored by
Yes.
me that multiple cases that say that there is the need for a causal nexus. So are you saying that it's wrong, or the state's taking a different position as to Booker, as to I guess all the cases that cited Booker, or am I misunderstanding your argument?
Respectfully, Your Honor, it's our position that there's no current binding authority stating that there is a causal nexus. However, in this case, it's clear that there is one.
Tell me whether a defendant, this defendant, was engaging in criminal conduct such that he would be denied the no duty to retreat jury instruction.
Yes,
Is
Your
that
Honor.
a question of law or question of fact, whether he was engaging in criminal conduct?
It would be, so the determination as for the jury instruction, whether or not it should be issued, that would be a question of law in that case.
It's what?
It would be a partial question of law to determine whether or not the defendant would receive the self-defense instruction. But in this case, the trial court did find that the evidence had it fairly raised self-defense, and it did give the instruction. But the trial court also found by the clear and convincing evidence that the defendant had engaged in criminal conduct, and the proof did support that. There was, even in viewing the facts in the light most favorable to the defendant, in the case, it isn't, the state wasn't required to discredit Ms. Harper's testimony, and she had stated.
Well, before you get too far away from that, if we were to find that the issue of whether he had was committing criminal conduct to be a question of law, which it possibly is, because it has to do with whether he was doing something that violated the law, then why would there even be a 404B hearing in this situation?
So those are two separate determinations. In the Rule 404B analysis, the state did have to prove the prior bad act by clear and convincing evidence, and it's a partial question of.
Well, I mean, the point is, did the jury have any role in deciding how the self-defense instruction would be given with or without the no duty to retreat language? Is it even a jury question? And beyond that, the judge sort of buttressed that ruling with a finding that it was admissible to provide context, right?
Yes, Your Honor.
Years ago, and as I look at you here, years ago being prior to your going to law school, probably, there was a widespread use of the notion of res gestae. Are you familiar with that?
No, Your Honor.
I didn't think so. And it was a way to open the floodgate to admitting evidence of a defendant's prior criminal conduct because it provided a picture of his situation at the time he committed the current crime, and it was called res gestae. We finally got rid of that, and I have to say I was a primary player in getting rid of that. But we had no longer gotten rid of that notion. Then along came context as an excuse for admitting this kind of evidence in a criminal trial. And I'm leery of context as a basis for admitting prior criminal conduct of a defendant, mainly because it has no limitations. And it tends to throw open the door. So what do you say about the use of context in this case to justify this evidence?
I understand that this court and the Tennessee Supreme Court are leery of contextual evidence. I do understand that. And that was one part of why the trial court did admit the evidence. The trial court also considered the fact that the defendant was going to raise self-defense, and the state knew that during the pretrial hearing, which is why this evidence ended up coming in part, because it would have led to jury confusion if there was no evidence establishing his unlawful activity.
How is that jury confusion? He's at a bar with his friends. He hits on a woman. She rebukes it, starts a fight. How would leaving the drug or the comment that he was engaged in drug sales, how would that confuse the jury if it's left out?
It would confuse the jury as it relates to the instruction itself. So the state intended to argue, and it did argue, that he was engaged in lawful activity and that he was not entitled to a no duty to retreat instruction. And in the case, while the defendant, the evidence did show that throughout the entire night, the defendant was selling drugs.
I'm having trouble. Ms.
Hoopenthal.
Hoopenthal. The state's pushing back on multiple cases that have already been decided by this court, and what I understand you to say is that you're pushing back because it's not binding authority, it's persuasive authority, basically. And so what I understand you to say is that an individual who, let's say, hadn't, paid their driver's license fees, has a revoked or suspended license, and for whatever reason that individual is involved in a bar brawl, similar to this case, that individual cannot avail themselves of the full jury instruction that our law allows for self-defense. That's the state's position.
Respectfully, Your Honor, the defendant, there was evidence that he was engaged in trying to sell drugs the entire night.
I mean, let's take it to
Yes, Your Honor.
not the drug sales, because I understand you're not going to get off the drug sales. We've tried.
Yeah.
Everybody's
Yes.
tried. What I want to understand is status offenses like tax cheats, people who, minor offenses that, you forget to pay a licensing fee or gun storage fees. All of those things, the state's position is, would deprive or strip that individual of their statutory right to self-defense or self-defense instruction.
No, Your Honor, because in this case, those...
Not in this case. I
I
gave you a
understand.
hypothetical.
I understand. It would depend on whether, in that, like, when you're evaluating it in terms of if it provides contextual evidence, are the two in some way correlated? Does it help the jury understand the entire narrative, the entire story? Because here, the act doesn't need to be the cause of the criminal activity, but it does need to be a cause. And here, if the defendant didn't go to the dogwood to sell drugs, his criminal acts would not have happened. And he had sold drugs he was attempting to sell drugs that entire night. The proof reflected that. And
I thought, since we're going back to this case, I thought that the state's theory was that this brawl was started because the young lady and her friends had rebuked the defendant's romantic advances multiple times. I thought that the state's theory was that this was about a guy who wouldn't leave a girl alone, and her friends coming in saying, hey, this has got to stop. Is that not true? It had really nothing to do with drug sales.
Your Honor, that is true. It did have a partial, drug sales were correlated, but his interactions with Miss Yoder were a partial cause to this. And it was the state's theory. But we can't look at it in a vacuum. We have to look at the entire picture, and that's why in this case, it did fill that conceptual void.
But there is no proof in the record that the defendant ever tried to sell drugs to Ms. Yoder or any of her friends. Is that correct?
From the proof, yes, we do not have that information. However, we do have the video evidence. We do have Ms. Harper's statements that they're.
But on the other hand, there is proof in the record that he came to this Dogwood bar to sell drugs.
Yes,
there is
that's
proof
correct.
in the record of that.
Yes, Your Honor.
Well, essentially what Judge McMullen is asking, and Judge Easter, there doesn't seem to be a causal nexus between his ongoing criminal conduct and the present charges. And a causal connection is generally required. So what is the causal connection between the possibility that his intent there that night was to sell drugs and his stabbing 2 victims to death as part of a fight? What's the causal connection?
Again, respectfully, the state's position is that the state does not have to prove a causal nexus. However, here, the connection is the defendant would have never been at the Dogwood if he wasn't trying to sell the drugs that night. He was at a bar earlier in the night. He didn't try to sell drugs there. They changed course and went to Midtown, went to the Dogwood bar to sell drugs. And
So assuming we apply the authority that we've already had issued by this court, we disagree with the position advanced by the state regarding a causal nexus. Okay, so the trial court erred, assuming that we disagree. So what is the prejudice, if any, in providing the instruction?
Yes, Your Honor.
Or not providing the
Yeah,
instruction?
I understand. So initially, I would state that no reasonable juror would find that the defendant was entitled to a self-defense instruction. He immediately went and had unprovoked, he punched Mr. Folks unprovoked. And after that point, the fight started. There was a brief break in time, and that element shows premeditation, at least for the first killing. The fight started, Mosley started to punch Mr. Bethard, and Mr. Bethard pushed him, which caused Mosley to fall to the ground. And the unarmed victims did not know that Mosley had brought a knife to a fist fight. At that moment, after he fell on the ground, he stood up, wielded his knife, and attacked and stabbed Mr. Clay Bethard.
But both of these issues that have been argued here by Mr. Russ this morning, and the state's addressing now, the not getting or receiving the full instruction on self-defense and the 404B issue were both properly objected to, preserved, and so we will be reviewing both of these issues under abuse of discretion. Is that correct?
Yes, that's correct. Yes, Your Honor.
But the prosecutorial misconduct in the closing argument, that is going to be plain error.
Yes, Your Honor, it will be a plain error review because the defendant failed to object, and defense counsel explained that he did not object because he strategically decided not to. He didn't want to draw attention.
And that was at the, when was that, at the motion for new trial? What
Yes, yes, Your Honor. And even in that case, he wouldn't be entitled to relief. We have no, in this case, the trial court made no findings because he didn't raise the premeditation comment in his motion for new trial. And at the end of the day, there was overwhelming proof in this case against the defendant. And, excuse me, I do want to briefly touch on the 404B analysis quickly before my time is up, just to explain again that the material issues here were not only the contextual background, but also that the state wanted to introduce the evidence to rebut the self-defense claims, and that this evidence would have the trial court implicitly found that the probative value had outweighed its prejudice because it didn't increase the likelihood that the defendant had a propensity for violence. The conduct was so different than the conduct actually committed in this case, and it didn't make it more likely that the jury would convict him.
You're talking about the comment that his intent to sell drugs at the location where the offense occurred. This is all what you're saying the trial court implicitly engaged in a 404B analysis on?
Well, partially. So the trial court had issued a limiting instruction, and in its order, it cited Rule 404B, I believe, 3 times. It just appeared that it forgot to state those explicit words. And at the end of the day, the jury's assessment of the proof, it didn't depend on this evidence. And the state rests on its brief for the remainder of the issues and asks this court to affirm the defendant's sentence, convictions, and the trial court's judgments. Thank you very much.
Thank you.
Just briefly, Your Honors. First of all, I wholeheartedly agree that a nexus is required here. By the state's theory, I guess if Mr. Mosley and his friends had just decided to go to the Dogwood Bar because they wanted a beer, then this never would have happened either, because it wouldn't have been at the Dogwood Bar. So that's a totally insufficient explanation for a lack of nexus between the criminal conduct and what happened afterwards. The secondary question that was asked, which is also important, why does it make a difference? Well, because of the facts that we've described. If the jury were to have heard that Mr. Mosley had no duty to retreat, that would have explained his 5 to 10 second pause or being sort of shuffled to the side, and then his decision to go and re-engage. If they hear he has no duty to retreat, that makes a lot more logical sense to his self-defense argument, and that's why there is prejudice.
I guess I'm going to have to see the videos
clearly,
because my understanding based on the brief is this is an ongoing brawl. It's an all-out brawl, and
yes.
It wouldn't have made a difference based on the facts as they've been outlaid, whether he had a duty to retreat or not. This was an ongoing brawl.
It was.
So
it was, and again, this is the 5 or 10 second interlude. I don't even know if you would call it that. That's exactly what happened, Your Honor. And it is true. Mr. Mosley started this fight. He hit Mr. Folks. I have trouble remembering who each of the parties are because there were several of them other than the victims. And then the reason that self-defense becomes pertinent is, again, because he's a small man who, though he started the fight, is now on the ground and being hit by 4 or 5 other larger men. And again, I think it's Exhibit 11 is all of the videos, but I think the most important one is number 9, because again, there's different angles, but that one is from the bar as everyone exits, that you can see, I believe, the best view of everything that happens. And yes, it is only about 60 to 90 seconds. It is an all-out brawl. It does spill across the street into the other side, and at some point, Mr. Mosley does get up and is kind of, several feet away, maybe to the end of the table here from the rest of the group, and then he does decide to go back in.
And that's when he pulled the knife.
And that is when he pulled the knife. Yes, you're right, Your Honor. But that's also the critical time for when I'm saying that if he has the full jury instruction, he has no duty to retreat there. How does he know they're not going to get up and come after him at that point? Further, and again, I haven't argued premeditation this morning, but I did in the brief, that 5 or 10 seconds is where, with reflection and judgment, free from excitement and passion, they're saying he takes a knife and then stabs 2 people to death, and that's first-degree murder. So it's very relevant. So anyway, I'll leave it at that.
Thank you.
Thank you.
Thank you both for your argument in this case today. And we'll move along to the next case. Please call it, please.